I'm a faculty member at the University of Baltimore. I teach in the clinical law program for the Juvenile Justice Project. And it's a little bit ironic that I represent individuals who have committed first-degree murder at a time when they were juveniles, because my grandfather was murdered in Baltimore City by 4 juveniles before I was born. But I certainly understand and appreciate the effect that had, not only on my mother, but on myself. That kind of trauma is intergenerational. But I've had a really unique opportunity over the past 4 years to pretty much exclusively represent lifers in the parole process. And you have my written testimony, and there are unique legal aspects to parole now after the Supreme Court has decided Graham, Miller, and Montgomery, so I won't get into that in my 2 minutes. But I do want to speak to a couple issues that I heard you all discussing in the earlier bill. I mentioned in my testimony that I have 2 clients who are currently before the governor, and I want to talk about one of them. He was sentenced to life in prison at the age of 16 years old in the 1980s, and he's now served 34 years in prison. And just now has he made it to the stage where he's been recommended to the governor. After 5 parole hearings, he's been vetted by 10 parole commissioners, and he's had a psychological risk assessment. And they're just now to the point where they're making that recommendation. So I just want to emphasize how thoroughly these people are vetted before they even reach that point, and how few are even making it to the governor. There's some legal fiction going on between parole and commutation and when people get diverted in the process, and I'd be happy to take questions about that. But the bottom line is very few lifers, juvenile or otherwise, are actually recommended for parole in the state of Maryland. So it's safe to say that those who are among the best of the best and can be released. Thank you.
A couple questions we've had on this bill. One is that, and I was talking to somebody who's on the parole board earlier this year, and I asked him that when they review these cases, he said it's only 2 members of the parole board that normally do these, that it's not the whole parole board, that they really only have, so you're talking about the decision now is just going down to 2 people.
That's actually not correct. So the initial parole hearing is conducted by 2 parole commissioners, and what happens is they make a recommendation. And if they want to move someone forward in the process, they recommend them for what's called a risk assessment. You'll wait about a year to a year and a half to have that risk assessment. There's only 1 clinician for the Department of Corrections who conducts those. At this point, the risk assessment results come back. They go back to those 2 parole commissioners. They take a look at the report in light of the case as a whole, and then they decide, are we going to move this case forward? If they do, it's considered an en banc, which means it goes before the entire parole commission. So all 10 parole commissioners consider the case, and then they take a vote about whether to move it to the governor. So every lifer case is considered by the entire parole commission.
Okay, is that in
Right, they need a majority vote, but all 10 consider the case.
Okay, so 2 hear it, and then the other majority never hear it. They just look at the facts or the file, and then they decide, they vote on it.
Well, you'd have to ask the parole commission a little bit more about what that process looks like, because whenever I've asked as an attorney for a client, they tell me that information is privileged. But what I can tell you is that the client doesn't appear in front of the entire commission, but they're reviewing the file, and those 2 commissioners who recommended the case be heard en banc make a presentation.
Okay, and just the other question I have, because I was just doing, said the other parole bill, but when we're looking at it, 27 states don't even offer parole on a first-degree murder, and of the ones that do, we're one of 3 that allow it as low as 15, which with dim credits I think worked out to be almost 12 years, 11 and a half, something like that. So I guess, don't you think that basically the governor is the stopgap in there that stops somebody from getting out so early? But in theory, don't you think, if we remove the governor from there, we would have the easiest of all 50 states as far as someone being eligible. Somebody literally just has to have has the parole board sign off in 11 and a half years. Don't you think that's really too early?
So I represent juvenile lifers now, but have represented other lifers in the past, and I can tell you I've never seen a case where someone has been recommended at their first parole hearing. So no, I don't think that happens. On average, my clients who are making it to the governor, very few of them who do make it that far, despite being exceptional candidates, have served over 3 decades, despite eligibility being at 15 years. So I don't think that the Maryland Parole Commission functions in a way that allows people to progress to the governor at 15 years. The Parole Commission is comprised at this point majority law enforcement officers. These are people who have an eye towards public safety and take these decisions very seriously.
Just one last follow-up, and I think you're very knowledgeable in this, which is helpful, because to be honest, this process is always confusing because we're not on parole boards. And
sure.
It came up on the last piece of legislation was asked, and I think the answer was it's up to the parole board to decide. So if you go in front of the parole board and they deny you, it is up to them. They could say you come back to us in 20 years, 100 years, 3 years. It is totally at their discretion. Is that correct?
That's right. So they can make one of 3 decisions. They can either say, we're moving you forward to a risk assessment. They can deny you outright, and that means that you'll never have another parole hearing again. That's called a refusal. Or they can issue a rehearing, and they can do that at any interval. So I've seen anything from 2 years to 10 years.
2 years to 10 years. Okay, thank you.
Just before we move over here, one of the things the Parole Commission can do is say that you can't get another parole hearing ever?
That's right, and those decisions are not appealable.
How often does that happen?
That's a great question. That, data about parole hearing outcomes is not available, but based on what I've seen, it's not as infrequent as you would think.
Okay. Senator Brochen, followed by Senator Cassidy. Thank you.
So, a couple questions. So, on Senator Huff's thing, you talked about the 3 recommendations, and one of them is for a risk assessment. Mm-hmm. So 2 people are making that decision, so I assume that it would be unanimous that the 2 would recommend a risk assessment, or can a 1-to-1 decision move a risk assessment forward?
No, the 2 commissioners who hold the hearing need to come to an agreement about what the recommendation is coming out of that hearing.
Okay. Second question. Are you sure that the answer you gave, Senator Zirkin, is correct, that 2 members of a parole commission can say you can never get a parole hearing again the rest of your sentence?
Yes, I'm certain of that. And I mentioned that there's no appeal. And if you look at the statute, the number is escaping me at the moment, but I could get back to you on that. That's actually written in that decisions that are made by 2 parole commissioners are not appealable. Now, what the parole commission will say is that you can write to them after 2 years and ask for reconsideration, but that is not a formal appeal.
Okay.
And it's totally discretionary.
Okay, so after 2 years, you can write for a reconsideration, and this has nothing to do with the fact with the part in the law that says that, in the part in the law that says you have to serve at least 50% of your sentence in a violent crime. Once you serve 50%, if they said no, you're never getting parole, you'd have the option of of writing to them in 2 years. If that was denied, could you write to them in another 2 years after that?
Theoretically.
Okay, so you can continue writing to another 2 years until you served your entire sentence.
Until you mandatory out, which of course never happens for lifers.
Okay, and then the last question is, you gave an example of a 16-year-old who's been in jail for 34 years. Could you give me the circumstances of the crime they committed and what they did?
Absolutely. So he was technically convicted of first-degree murder. Maryland has sort of this legal fiction where if you commit what's called felony murder, that goes in as a first-degree murder. So in that situation, the state alleged that he was part of a robbery of a gas station. The state never alleged that he was the actual shooter, but said that he stood behind the actual shooter during the robbery. And he was convicted of first-degree murder for his part in that crime.
I actually put that bill in 2 years ago to repeal that, and unfortunately it didn't go anywhere, but I did put that bill in to repeal that. Thank you.
Just refresh me, was the parole commission 11 members?
10, I believe.
In their staggered terms?
Yes, that's correct, of 6 years.
The 6 year staggered terms?
Yes.
And so, and do they come up in batches or?
I'm not sure I
mean,
understood the question.
I guess, were they appointed in like groups, so that how many, like in a 4-year governor's term, how many parole commissioners do they get to appoint usually?
I don't know the answer to that question.
Thank you.
Thank you.
Thank you so much.